Here in Australia, there's no presumption or rule that a child or children will or should live with the parents equally following separation. The children's best interest is the paramount consideration, and whether living with each parent equally is in the child or children's best interest will depend on the particular facts and circumstances of the family. When a lawyer is trying to ascertain whether an equal time parenting arrangement is likely or in the child's best interest, they'll often ask questions about the parenting dynamic. How well do they get along with their co-parent or with the other parent? Is there evidence that those parents can communicate flexibly and in the child's best interest? Can they put the child or children's needs above their own wants or desires? From a practical standpoint, we might consider how far each parent lives from the child or children's school and from one another. We might consider whether the parents' work schedule or where they actually work, the location of their work, whether that might impact their actual ability to care for the children equally. In this video, I'm going to read directly from two publicly available cases. And within these cases, the experts explain and provide their expert opinion in relation to what type of parenting dynamic supports an equal time parenting arrangement. So let's hear directly from an expert. The first case is Bills and Brueggelmann, and I'm going to read directly from paragraph 35. The secondary proposal of equal time shared parenting is not considered appropriate due to the long history of very poor parental communication and the likelihood that the co-parenting relationship with sick continue to be extremely strained. Current accepted research clearly indicates that an equal time shared care parenting arrangement is very unlikely to be sustainable and in the child's best interest unless the parents are able to be flexible, cooperative, and child-focused in their communication and co-parenting. Paragraph 36. As would be apparent, the level of co-parenting cooperation between the parents needed to successfully implement an equal time residential regime is considerably deeper than that required for the successful implementation of equal shared parental responsibility. We no longer refer to it as equal shared parental responsibility, but that is talking about decision making, not time with. For the latter, so decision making, all the law requires is that the parties, in consultation, in good faith, on the occasional basis that major long-term issues arise, whereas the former, so an equal time arrangement, demands their frequent interaction, cooperation, and consensus on a host of both important and menial day-to-day issues. That deeper level of cooperation between the parties is not always presently achievable. I'm about to read directly